Start. The question of maintainability of a writ petition under Article 226 in the case of a money claim again came up for the consideration in the case of Hindustan Petroleum Corporation Limited and others versus Dolly Das, reported in 1999 4 SCC 450, and it was held that for invoking the writ jurisdiction, involvement of any constitutional or statutory right was essential, and in the absence of a statutory right, the remedy under Article 226 could not be availed to claim any money in respect of breach of contract, tort, or otherwise. Stop. It was reiterated that in absence of any constitutional or statutory rights being involved, a writ proceeding would not lie to enforce a contractual obligation, even if it is sought to be enforced against the state or its authorities. Stop para. The maintainability of writ petition under Article 226 in disputes relating to terms of contract with a statutory body fell for consideration in the case of Kerala State Electricity Board and others versus Kurian E. Kalathil and others, reported in 2006 SCC 293, and it was held by the Honorable Supreme Court that the writ court would not ordinarily be the proper forum for resolution of disputes relating to terms of contract with a statutory body and disputes arising from contractual or commercial activities must be settled according to ordinary principles of law of contract. Stop. The observations made in the judgment in this regard are as follows: the interpretation and implementation of a clause in a contract cannot be subject matter of a writ petition. Stop. Whether the contract envisages actual payment or not is a question of construction or contract. If a term of a contract is violated, ordinarily the remedy is not the writ petition under Article 226. We are also unable to agree with the observations of the High Court that the contractor was seeking enforcement of a statutory contract. Stop. A contract would not become statutory simply because it is for construction of a public utility and it has been awarded by a statutory body. Stop. We are also unable to agree with the observation of the High Court that since the obligations imposed by the contract on the contracting parties come within the purview of the Contract Act, that would not make the contract statutory. Stop. Clearly, the High Court fell into an error in coming to the conclusion that the contract in question was statutory in nature. Stop para. A statute may expressly or impliedly confer power on a statutory body to enter into contracts in order to enable it to discharge its functions. Stop. Despite arising out of the terms of such contracts, or alleged breaches have to be settled by the ordinary principles of law of contract. Stop. The fact that one of the parties to the agreement is a statutory or public body will not of itself affect the principles to be applied. Stop. The disputes about the meaning of a covenant in a contract or its enforceability have to be determined according to the usual principles of Contract Act.